I'm Drew Stevenson, and this is a lecture for my professional responsibility class about the ethics of witness preparation. This was a subject of Formal Ethics Opinion 508, which the ABA published in August of 2023. Providing a witness with effective preparatory guidance is a component of the thoroughness and preparation element of competence under Model Rule 1.1, as well as Rules 1.3, which is about diligence, Rule 1.4, which is about communication with a client, and Rule 2.1, which is about being an advisor to a client. Now, this area can create ethical issues. As the ABA says, the line between legitimate witness preparation and guidance versus unethical efforts to influence witness testimony can be ambiguous. The reason for this is that there are concurrent ethical duties to represent the client diligently and competently, but also to refrain from improperly influencing witnesses. Lawyers have a number of different slang terms or jargon words for improper coaching. Sometimes we call it coaching the witness, or the ABA opinion repeatedly calls it horse shedding. Other people will call it wood shedding or sandpapering. So what can a lawyer do? Well, it's always acceptable for lawyers to remind the witness that they will be under oath and to emphasize the importance of telling the truth. And you can explain that telling the truth can include a truthful answer of, "I do not recall." It is acceptable for lawyers to explain case strategy and procedure to a witness, and that includes the nature of the testimonial process or the purpose of a deposition. Some witnesses are unfamiliar with the idea that they will encounter cross-examination from the other lawyer, or redirect or recross, and so forth. It is always acceptable and appropriate to suggest proper attire and appropriate demeanor and decorum, and to provide some context for the witness's testimony. A lot of times, prospective witnesses don't understand how their testimony actually fits into the case or what their testimony is being offered to prove. It's appropriate for lawyers to inquire into the witness's probable testimony and recollection. You should know ahead of time, or at least have a general idea of what the witness or your client is probably going to say. And it's okay to identify other testimony that is expected to be presented and explore the witness's version of events in light of that testimony. If you already know that other witnesses are going to say something contradictory, then that can frame some of the types of questions and preparation that you do with this witness. It's even okay for lawyers to suggest a proper choice of words that might make the witness's meaning clear, and to tell a witness not to answer a question until it has been completely asked. Some witnesses are really bad about interrupting and volunteering information or guessing what the question is. And it's good to emphasize with a witness the importance of remaining calm and not arguing with opposing counsel or with the judge, for that matter. It's okay and acceptable for lawyers to tell the witness to testify only about what they know and remember and not to guess or speculate, and to familiarize the witness with the idea of focusing on answering the question that was asked instead of volunteering other information that they haven't been asked for. In other words, when it comes to preparation of a client or witness for a testimonial event, such as a trial or deposition, there is a fair amount of latitude in the types of lawyer-orchestrated preparatory activities that are recognized as permissible, the ABA says. On the other hand, not everything is ethical or permissible. You may remember that Model Rule 3.4b prohibits a lawyer from advising or assisting a witness, whether that witness is a client or not, to give false testimony. So, for example, it is unethical to tell a witness to downplay the number of times a witness and a lawyer met to prepare for trial, or to encourage a client to misrepresent a location of a slip and fall accident in order to have a more viable claim. Other types of unacceptable or improper witness coaching and influencing would include scripting or programming a witness's testimony, really telling them exactly what to say, or knowingly violating a court order that you shouldn't talk to certain people, or encouraging a witness to present fabricated or made-up testimony. Sometimes lawyers will try to influence a witness's testimony improperly while the testimony is ongoing, like winking at a witness during the trial testimony to signal to them that they should elaborate on what they just said, or they did a good job, or trying to cue them that they should backpedal on what they just said, or kicking a deponent under the table. Both of these are inappropriate. It's inappropriate to surreptitiously or secretly pass notes or kind of whisper under your breath to a witness mid-testimony, or mouth words to them that you want them to say. The ABA ethics opinion notes that there's a familiar type of kind of subtle or covert coaching that's called the speaking objection or subjective objection. And so these are statements that go beyond just stating the objection or basis for the objection, and are intended instead to coach the witness and impede the deposing attorney's discovery. So instead of just saying, "Objection, Your Honor, this is hearsay," or "Objection, there's no foundation for that question," the lawyer says a few other things to sort of cue the witness about what they should say next if the other lawyer rephrases the question and asks it again. Sometimes lawyers will try to interrupt the testimony when it's underway to do damage control, and so they'll ask for a break or recess so that they can talk to the witness about what they just said was wrong and they need to backpedal or backtrack. Some will insist upon breaks while a question is pending for the apparent purpose of coaching the witness in a private conference about how to answer the question before they have a chance to answer it. So, to conclude, under the model rules, a lawyer's failure to prepare or guide a witness at all could violate the ethical duties of competence and diligence. At the same time, witness preparation becomes unethical when conduct transgresses the model rules that prohibit interfering with the integrity of the justice system or obstructing another party's access to evidence. And that concludes this sort of mini lecture about the ethics of witness preparation and ABA Formal Ethics Opinion 508. I'm Drew Stevenson at South Texas College of Law.